Thank you, Mr. Chairman. Mr. Meadows mentioned one instance in which Secretary Clinton said that she did not mail any classified material to anyone. Actually, she said that several other times. But it is accurate, Director Comey, that you found at least 110 instances of when she had emailed classified material.
110 that she either received or sent.
Right. And it also is accurate that, quote, Clinton's lawyers cleaned their devices in such a way as to preclude complete forensic recovery.
Correct.
And also, when Secretary Clinton said that nothing she sent was marked classified, and you said in your press conference, but even if information is not marked classified in an email, particularly our participants who know or should know that the subject matter is classified are still obligated to protect it. Do you feel that Secretary Clinton knew or should have known that she was obligated to protect classified information?
Yes.
With her legal background and her long experience in government. Also, she said at one point that she has directed all emails, work-related emails, to be forwarded to the State Department. Is it also accurate that you discovered thousands of other emails that were work-related other than the 30,000 that she submitted?
Correct.
Before I came to Congress, I spent several years as a criminal court judge. Presided over several hundred felony criminal cases. And I can assure you that I saw many cases where the evidence of criminal intent was flimsier than the evidence in this case. But do you realize, or do you realize that great numbers of people across this country felt that you presented such a strong, such an incriminating case against Secretary Clinton in your press conference that they were very surprised or even shocked when you reached the conclusion to let her off? Do you doubt that great numbers feel that way?
No, I think so, and I understand the questions. And I wanted to be as transparent as possible. We went at this very hard to see if we could make a case, and I wanted the American people to see what I honestly believed about the whole thing.
Well, do you understand, as the chairman said earlier, that great numbers of people feel now that there's one standard of justice for the Clintons and another for regular people?
Yeah, I've heard that a lot. It's not true, but I've heard it a lot.
Well, even the ranking member who was here, who of course, as we understand, had to defend Secretary Clinton as strongly as possible, he almost begged you to explain the gap between the incriminating case that you presented and the conclusion that was reached. Did that surprise you, that he felt so strongly that there was this big gap?
No, not at all. No, it's a complicated matter. It involves understanding how the Department of Justice works across decades, how prosecutorial discretion is exercised. I get that folks see disconnection, especially when they see a statute that says gross negligence. Well, the director just said she was extremely careless, so how is that not prosecutable? So it takes an understanding of what's gone on over the last 99 years. What's the precedent? How do we treat these cases? I totally get people's questions, and I think they're in good faith.
Do we talk about gross negligence here, and you said that Secretary Clinton was extremely careless with this classified material and how dangerous it could be, how threatening to even to people's lives that it could be to disclose classified material. Do you agree that there is a very thin line between gross negligence and extreme carelessness? And would you explain to me what you consider to be that difference?
Sure, Judge. Congressman, as a former judge, you know there isn't actually a great definition in the law of gross negligence. Some courts interpret it as close to willful, which means you know you're doing something wrong. Others drop it lower. My term, extremely careless, is I'm trying to be kind of an ordinary person. That's a common sense way of describing it. Sure looks real careless to me. The question of whether that amounts to gross negligence, frankly, is really not at the center of this, because when I look at the history of the prosecutions and see it's been one case brought on a gross negligence theory, I know from 30 years, there's no way anybody at the Department of Justice is bringing a case against John Doe or Hillary Clinton for the second time in 100 years based on those facts.
You ended your statement to Congressman Cooper a while ago saying once again that no reasonable prosecutor could have brought this case. Yet you also mentioned earlier today that you had seen several of your friends and other prosecutors who've said publicly, many across this country, that they would have been glad to prosecute this case.
I smile because they're friends, and I haven't talked to them. I want to say, guys, so where were you over the last 40 years? Where were these cases? They just have not been brought. For reasons that I said earlier, it's a good thing that the Department of Justice worries about prosecuting people for being careless. I don't like it. As a citizen, I want people to show they knew they were breaking the law, and then we'll put you in jail.
Of course, you know many people have been prosecuted for gross negligence by the federal government, by the FBI.
Gentleman's time has expired.
Thank you.